well. So the title on my paper is, or my paper I'm working on is Intellectual Property as Charity. And typically, intellectual property and charity law are thought of as two largely unrelated bodies of law. I'd like to argue that actually the prevailing theories of both are quite similar. Right? So both intellectual property and charity law, the prevailing theory of each is a welfarist theory. So intellectual property, as you all know, is intended to solve market and government failures in discoveries and works of authorship using indirect subsidies. Likewise, charity law is intended to use indirect subsidies to solve market and government failures in charitable goods. So you can see the obvious parallel. Of course, there are alternative non-consequentialist theories of both. And I'll save those for later because it enters into the discussion in the paper in an important way. So essentially, both intellectual property and charity law are about the public good of innovation. There's different kinds of innovation. Right? So intellectual property goes to technological and aesthetic innovation, and charity law goes to social innovation. So I'd like to suggest that at least looked at in a certain way, both intellectual property is kind of a category of charitable activity, or a category of altruistic activity. Right? We're trying to encourage people to engage in activities that will produce a public benefit and have positive externalities for the public. So what causes these market failures in both intellectual property and in charity law? Primarily free riding. Right? Some transactions costs as well. What's the primary cause for the government failures? I would point to primarily transactions costs. The government doesn't necessarily know what to directly subsidize or how much to directly subsidize it. Intellectual property is good at solving some of the market failures, right? It's good at solving some of the free riding issues, and it's good at solving some of the government failures, but not all of them. Right? So intellectual property can help solve the free riding issues, and it can help solve some transactions costs in some circumstances, but it can also increase transactions costs, especially on consumers, especially as the scope of intellectual property rights gets broader. Charity law is marginally good at solving both free riding problems and transactions cost problems, but not especially efficient at solving either. However, one area in which charity law does have some advantages is that it gets more and more efficient as transactions costs start to go down. I pointed to that in a paper I wrote called Solving Charity Failures, showing how especially new technologies like crowdfunding have helped reduce transactions costs on charitable or quasi-charitable altruistic activity. So what can we learn looking at this kind of structural similarity between intellectual property law and charity law? Well, I think it can help us think about some of the recent conflicts between competing theories of the justifications for intellectual property that people have been talking about lately. Primarily tensions or the kind of increasingly perceived incompatibility between consequentialist and non-consequentialist theories of intellectual property law. So I think that this relationship between intellectual property and charity law can help us think about how we might be able to reconcile these apparently irreconcilable positions on the underlying justifications for intellectual property. In other words, how should we think about squaring these two issues? And I think one reason, especially that comparing intellectual property to charity law can be helpful is because in many respects, historically, intellectual property law has been much more effective at accomplishing some of its initial goals than charity law was. It's sort of an example of when you've got a hammer, everything looks like a nail, and the better your hammer, the more nails you tend to see, right? So when it seems to work well, you try to produce more of it. When it doesn't work quite as well, as is the case in charity law, perhaps people are less aggressive about expanding its scope. Right? So charity rule sees the role of altruism in the promotion of charitable activity, I think in a much more cogent way than intellectual property law tends to see the role of altruism in the promotion of technological and aesthetic innovation. As a consequence, I think charity law scholars are more skeptical of expanding the scope of charity law in particular circumstances, and more willing to rely on individual action rather than on expanding the scope or the involvement of government regulatory action in the charitable field. So, in particular, charity law recognizes that a great deal of altruistic activity is actually not captured by charity law at all, right? The primary tool of charity law in terms of solving the market and government failures in charitable goods is the tax deduction. But the overwhelming majority of people in America can't even claim a tax deduction in the first place and aren't in fact incentivized by the tax deduction for charitable giving. So we see a lot of altruistic activity that occurs outside the formal scope of charity law and its tools for promoting that activity. And I think it's harder in some ways to see that in the case of intellectual property, right? And the overwhelming majority of the production of discoveries and works of authorship, I would contend, also occurs, in a sense, altruistically, right? People don't do it necessarily in response to incentives, right? They don't do it in response to the potential for a copyright or a patent, but simply because they're engaging in the activity in order to increase social welfare in one respect or another. They want to engage in that activity. We see more and more of that as the costs of producing intellectual ideas and works of authorship goes down. Right? So there's a strong altruistic element to the production of that kind of good. So my suggestion would be that perhaps we can segment the role of government to focus on where it's effective rather than where it's less effective. So just like as in the case of charity law, we want to tailor the incentives provided by the deduction to ensure that we capture the people who are going to be incentivized to engage in additional altruistic activity, while not providing an additional incentive to people who wouldn't otherwise need it to engage in that activity. Perhaps from a government action standpoint, we ought to be thinking about the scope of intellectual property in more explicitly well-phrased terms, right? To ask, where is it that the government can have an effect, can make an effective intervention and provide an incentive that's actually going to increase public welfare? But I think that's where we can interestingly work in this idea of non-consequentialist values as well, right? Because to the extent that people still engage in this particular form of altruistic activity, to the extent that people engage in making discoveries or producing works of authorship, outside of their need to receive these kind of incentives, people can still engage in individual altruistic behavior, right? And people do that all the time. In fact, as we see the transactions costs on that kind of altruistic behavior go down, we see more and more people engaging in that particular form of altruism. And again, I would point to something like the crowdfunding revolution, in which we see large numbers of people providing additional resources to creators outside of a copyright context, right? They're engaging in altruistic activity, giving to creators to produce on their own. And so my suggestion would be that to the extent that we think that there are non-consequential justifications for thinking about the deserts of discoverers and authors, perhaps those non-consequential values ought to be cashed out in individual terms rather than in terms of regulatory structures created by the government. So it's a very early stage paper. I'm really interested in thoughts or comments or suggestions that people might have on that. Sure?
So one question about the analogy is, I mean, is there anywhere in charity law where there's a concern about like liability or a chilling effect? Is there any reason you want to kind of cabin in the incentive in charity law that you would, the same way you'd want to in IP?
Right. Well, it's generally thought, so most charity law scholars, unlike myself, are tax scholars. So they tend to think of charity law in terms of the effect on the public fisc. So it's a trade-off between providing this indirect subsidy to charitable activity versus having that money available in tax revenue to the government. So the trade-off is really between individuals being subsidized in order to choose whatever kind of altruistic activity they think is valuable, and then the government kind of indirectly chipping in an additional subsidy, versus those people having to pay additional taxes to the government, which can then distribute the money on its own. So that the sort of the values trade-off comes there instead of on the IP side, which is slightly different, but I think it's in some ways it's kind of structurally, it's still kind of structurally similar. Sorry. Yes.
To what extent isn't IP already charity law? To the extent, anyway, that many of the types of activities that qualify for innovation or creativity receive tax deductions and other sorts of things from the government. So, I mean, is this a situation in which we're paying twice for the same content? By giving intellectual property rights plus tax credits for innovation and creativity and business expenses and all the rest of those sorts of things?
Yeah.
And if so, how do we disintegrate?
That's actually a great point, which I didn't have a chance to get to. But yeah, you're absolutely right. I mean, one of the reasons that I think that intellectual property is arguably a subset of charity law is that the promotion of innovation is a charitable activity, right? So charities are perfectly capable of engaging in that kind of activity and it being treated as charitable for deduction purposes by the government. And that said, I think it could still be seen as complementary, right? Because I do think that there are ways in which, at least arguably, intellectual property is more efficient at solving certain kinds of market and government failures than charity law is. Certainly, I think the transactions costs surrounding intellectual property are lower, at least ex ante, from the perspective of the potential inventors and authors than it would be, because the charities are still going to run into many of the same kinds of information cost issues that the government does in terms of deciding, where to direct its innovation resources. So I think on the front end, there's still a potential role for intellectual property. What I'm suggesting more is that it ought to cause us to think about, where intellectual property should start and when it should stop, right? So what's the appropriate role? When is it effective? And when should we think about utilizing other tools to engage and promote those ends more efficiently? Sure.
I'm not a tax scholar, so when you say charity, I think when I teach in contracts and, gifts without consideration can be revoked, et cetera, I don't have an answer, but as you're considering the analogies, you might consider that type of analogy. Is there one in IP?
Yeah, well, I think the analogy I would give is that both in the case of intellectual property and in the case of charity law, kind of the bulk of charity law scholarship, I think that the kind of scholarly discussion is in many cases driven by the lens that people use to look at it. So because most charity law scholars are primarily tax scholars or coming from a tax background, they tend to think about charity as defined by the federal tax code, which is a very different definition than I think most of us would adopt, right? So for example, if I put $1 in the cup of a homeless person on the street, I call that charity, but from the perspective of a charity law scholar, it's not, right? Because giving to an individual is not a charitable gift, right? It has to be given to a 501c3 charitable institution, right? So there's a conceptual way in which the framework that most charity law scholars use to think about charity doesn't capture a lot of altruistic activity because it's outside of the scope of what they care about. And I think the same thing is true, at least in some respects, when it comes to, at least historically, a lot of IP work, in the sense that people tend to think of intellectual property in terms of the rights that are the kind of the exclusive rights granted around it, without always being as cognizant of the extent to which people are continually producing discoveries and works of authorship outside the scope of any interest in the IP system, entirely effectively altruistic, right? Kind of producing them for the public to consume willy-nilly without any concern for this kind of incentive-based compensation, right? So just like charity law scholars frequently don't recognize or have difficulty kind of conceptually recognizing that people engage in altruistic behavior without receiving a subsidy, although they've become more cognizant of that. I think it can be easy to forget that people engage in authorship and invention without receiving a subsidy as well. We miss that when we focus on people's, the people who do choose to assert those rights as opposed to those who don't. Sure.
So you said a couple times that the issue would be recalibrated as the cost of creation goes down, right? Because as we progress forward technologically, the act of creating is easier. It requires less of a transaction. I would suggest that maybe while the cost of producing is going down, the actual balance isn't in the cost of producing in a vacuum, but rather just the question of the difference between how much is the cost to produce and how much is the cost to copy, right? Because that's the actual place where the government has to step in and regulate is because it's cheaper to copy than it is to produce. And so even if the cost of production goes down, as long as it's still cheaper to copy, that incentive stays the same. So
I guess I would say I think there's a whole range.
Mm-hmm.
I mean, I'm not only concerned. I don't think that the only relevant issue is on the side of the producer and the person who's bringing it to market.
Mm-hmm.
I think there's a whole range of transactions costs which are being affected in large part by technology, right? Not just on the producer side, but also on the distribution side, and also on the side of the consumers, right? Because one of the reasons in the past, I would argue, that it was difficult for people to engage in this kind of altruistic behavior with respect to works of authorship and discoveries was that information costs were really high, right? And engaging in those transactions was really expensive. Well, now we have technologies that make that really cheap, and lo and behold, right, people are suddenly cashing out all of these altruistic values that previously had been too expensive for them to engage in, right? So the transactions costs work in multiple directions, and I think that it's important to take account of all of them, especially to see the connection between the kind of altruistic impulse. I mean, I guess the key insight for me here, at least in one respect, is that both IP law and charity law are fundamentally about public goods, about positive externalities, and how do we maximize their production. Sure.
So I think that probably nobody would argue with you that at least a subset of creators, right, are created for altruistic, if you define altruism to encompass like the fact that it gives me an emotional reward, right? But I guess my question would be, so but then those people either don't get patent protection potentially, or, so the question would be, how does that interplay with IP, right? So are you suggesting that we need to acknowledge that, and then do we make it easier for people to then dedicate stuff to the public? Is that one? Or do we use that as a way to create an exception to infringement? I mean, because it seems to me that it's true that some creations potentially are not made for utilitarian reasons, but or are you suggesting that those things should not be protected with IP because we don't need the IP incentives and we should switch to the tax? So I'm trying to figure out like what would be how will we change the balance between the two?
I would kind of say at this point all of the above. I think it kind of depends on the circumstances, and I'm not sure that there's necessarily one right rule or one good approach for everything. I think it's very contextual, and the role that altruism plays on both ends of the equation really depends on the particular public good in question and the people who value it and are interested in consuming it. I guess my point is that the fact that people engage in altruistic activity, especially direct altruistic activity, without even receiving a charitable deduction in relationship to this kind of work, suggests that there's space for people to play out some of these non-consequentialist moral values of investing in this kind of work outside of the role of government, right? The one thing that I think IP law scholars have maybe not considered as much as they could is the potential role for extra-governmental individual engagement in the subsidy of intellectual property rather than government regulatory subsidy of